Okay, so why don't we get started? The second panel is on cross-cutting issues. The moderator is Michael Pantel, who's an attorney with the Environmental Defense Fund and very significantly an alumnus of Columbia Law School. Michael.
Hello, everybody, and welcome back. Our first speaker on this panel, Cross-Cutting Issues, is Eric Schaff. He serves as the Regional Counsel for EPA Region 2. He's been with EPA since 1984, served in his current role since 2002. Without further ado, Eric.
Okay, thank you, Michael. Good morning, everyone. Excuse me?
I'm going to get your PowerPoint now.
Okay, good. And it's this area?
Correct. Is that right?
Okay. Okay, it sounds like we're good to go. All right, I'd like to add my thanks to everyone else's, to Mike Gerard, as well as Columbia Law School and all the other people who have worked on this conference, both for this one and lo these many years. I didn't realize it was 11, but I knew it was a long time. It's been a great conference. And speaking of conferences, the last time we had this conference, 2 years ago, we were in the first term of the Obama administration, and the administrator for EPA was Lisa Jackson, who, as many of you know, had very, very deep roots here in Region 2. Lisa Jackson left after the election. She gave her notice soon after that, in December of that year. And Gina McCarthy, who is our current administrator, was confirmed in July of 2013. And as administrators will, and Lisa had done this before Administrator McCarthy, Administrator McCarthy issued a series of themes. These are the things that are important to her in her tenure as administrator. And you'll see this emphasis, which is going to be a recurring one, very important for all of our work, but also in enforcement, making a visible difference in communities across the country. Communities will come up over and over again. What are the rest of her themes? Climate change, taking action on toxics, water. We're also going to be tending to our partnerships, state, tribal, and local partnerships. We'll be tending to ourselves, making sure that EPA itself is a high-performing organization, and, of course, working toward a sustainable future. Now, proceeding along this framework within which EPA's enforcement will take place over the next couple of years, we then turn to the Assistant Administrator for the Office of Enforcement and Compliance Assistance, Cynthia Giles. She has her EPA enforcement goals. These are the three main headings in her goals. Tough civil and criminal enforcement, of course, for violations that threaten what? Communities. This next one, which we're going to spend some time on in a moment, vigorous enforcement program for the future, next generation compliance, not just enforcement, but compliance. And once again, an emphasis on our partnerships, strong EPA, state, tribal, environmental protection. Now, before we go on and talk a little bit about next gen, I also want to fill in the last of the framework issues. And by the way, there's more detail on all of this, and you'll find it in the materials that are online. Enforcement initiatives. We've been doing this since FY 2005. We've done 3 complete cycles. Each one is 3 years. And we're now in the first year of the 4th cycle, 2014. The initiatives that we're doing for this cycle are the same as for the last one. Sewage and contaminated stormwater, CAFOs, concentrated animal feeding operations without a permit, air toxics with a focus in particular on leak detection and repair, flares and excess emissions, the big facilities, the widespread air pollution, NSR PSD, mineral processing, not such a big deal in Region 2. There are other regions that have much more of that. Energy extraction. One of the gentlemen for the last panel had a question concerning fracking and how that's all going to work out. I think that's an evolving area in Region 2. We'll have to see how that all pans out. But that's one of the enforcement initiatives. So now, let's go to next generation compliance. What's this all about? This is really the way the agency intends to carry out enforcement for the rest of this administration. 5 components: more effective rules, advanced monitoring technology, electronic reporting, increased transparency, and innovative enforcement. What does all this mean? More effective rules. We're trying to get rules that are simpler. I mean, we've all had the experience. There was references made to how thick the environmental regulations can be. They're not all models of clarity either, I can assure you, and anyone who's ever tried to wade through them knows this. So we're striving for simplicity, designed to try to make compliance the default. I'll give a couple of simple examples. On the screen you see the gas nozzles. Well, you can only put a certain kind of gas nozzle on a certain kind of tank, otherwise it just won't fit. Speed bumps fit into that same kind of concept. Market mechanisms. Show people why. Market. Let the market work. It's cheaper to do certain things in a certain way, and people will move in that direction. Transparency as an accountability tool. We find that when communities, and affected communities, know what's going on in nearby facilities, and the facilities know that the community knows what's going on, the facility is that much more likely to comply. Why? Because they don't want to get into trouble with their surrounding community. Self and third-party certifications. It kind of speaks for itself. All right, so now, advanced monitoring technologies. Let's spend a moment on that. We've got a lot of tools, and they're all evolving, as you may imagine. The picture on the screen right now is a monitoring buoy in the Charles River. It sort of bounces up and down in the Charles, and it collects all kinds of data that ultimately is uploaded to a website. We can then access it. It's as close to real time as it gets. It's about every 15 minutes we get an upload of this stuff. And this happens to be in Region 1. Region 1 also owns one that bobs around in the Mystic River. And this tells us about algal blooms in real time. You know, there's a theme in all of this. I mean, one of the things we'd like to try to do, enforcement has been traditionally what? Penalize, remediate. You know, there's a lot of that, and it's an important part of the program. But I think it's also a good thing if we can move toward identifying things in advance, anticipating, and preventing. And so that's what some of this is directed toward. All right, let's take a look at advanced monitoring some more. This is a nice picture, nice blue sky, pretty day. I don't know how many people hang out among these kinds of tanks on a day like this, but there's somebody up there at the top of the tank wearing a hard hat, it looks like, in this particular case. This is a tank that contains benzene and toluene. No evidence of a problem. Sounds great. Now, if we take a look at the same scene through a particular kind of camera called a FLIR camera, it's the picture on the right there. It's not quite such a pretty picture anymore, and I've looked at that. And these are all the emissions that are coming from a bad seal on that tank. What you see sort of billowing off the top of the tank, benzene and toluene. That's not something that you want to have. So we have tools now that can allow us to see that where the naked eye could not, making the invisible visible. Another one of those tools. This one is called Passive Fourier Transform Infrared Spectroscopy, PFTIR for short. And these numbers all come from some settlements we had a year or two ago. These come out of Region 5, as it turns out, BP Whiting and Marathon Battery. But it shows the contrast between what the companies were estimating, based on the best engineering, you know, whatever they could do. It's the blue. These are emissions that were associated with flares that the company had. The blue is what they were estimating. The red is the actual data that we found through this advanced monitoring technique. So how are we going to get this information coming in? There'll be plenty of it. So how are we going to get it? Are people all putting things on little pieces of paper, sticking them in envelopes, putting a stamp on them, taking them to the mailbox? No. So what we want to do is we want to get it coming in electronically. All right? And we're looking for more and more ways to try to do that. TurboTax. I mean, we're using our own mechanisms. We're using mechanisms that are developed on the outside. The NIPT's e-reporting rule is a current example of all that. It was proposed just about a year ago, and we're just anxiously awaiting the completion of that process. Increased transparency. This one kind of speaks for itself, you know. Transparency does tend to drive performance. A couple of examples of this is the Safe Drinking Water Act consumer confidence reports, where water suppliers provide kind of a report card for themselves on the quality of the water that they're providing to the consumers. And that has a tendency to provide a nice feedback mechanism between the water supplier and their customers. And an obvious example, restaurant health inspection grades. Ask yourself, how do you feel when your favorite restaurant posts a C in the window? You feel good about that? What are you going to do about it? You're going to say something, right? That's how this process works. Okay, so what does this have to do with enforcement? Well, all of these concepts can be included in one form or another in enforcement settlements. And we're looking for opportunities to do that. Some of these make dandy steps, I guess. If anybody's looking to make a proposal to us, we're more than happy to listen along these lines. So what can be in these settlements? Fence line monitors, electronic reporting, public posting, the self and third-party certification that I talked about earlier. All of these are possibilities. And this is just another example of what happens when you do this sort of stuff. I'll be sort of simplistic about it. What we really like is look at that line. See how that line is going down over time? Starts out with a lot of violations, ends up with few. We like those kinds of lines. When you're a regulator, that's exactly what you live for, a line like that. Okay, let's talk a little bit about some case highlights here in Region 2. Whenever I've done this update, I always do our local water bodies, and I'm not going to make an exception today. I won't spend much time on them because Walter Mugden is going to be talking about some of these a little bit later. Hudson River. We've currently started our 5th season of dredging. There's some TV shows that don't run that long, but it looks like we're probably going to wrap this one up pretty soon. The end is in sight. We are anticipating one more year of dredging, 2015, and then after that we have some additional stuff that has to be done, habitat reconstruction, and decommissioning of the Fort Edward dewatering facility, and we think that will be done in 2016. So 2016, that's when we're going to have the next one of these. So I hope we'll have some good news for you the next time you come. Sign up now so that you can hear what's going on with the Hudson. Passaic, another big one, right? We've done a lot of enforcement on the Passaic, administrative orders, various removals. The RFS for the entire lower Passaic River study area, 17 miles of it, is being done right now, being concluded fairly soon. And but the big news on this one is that we have a proposed plan that was issued in April of 2014. And this plan calls for bank-to-bank dredging. And so remember, it's only for the lower 8.3 miles, but bank-to-bank dredging and capping. And since it's a capping remedy, we have to dredge far enough down at least so that we don't increase the flooding danger as a result of putting the cap on the bottom of the river. Lowest 2.2 miles will be dredged to a depth allowing for federally authorized navigation channel. Public comment period, this slide is wrong. I swear it was right when I wrote it. We extended the public comment period yet again this week, and so now it's August 20th. Okay, I couldn't resist this one. We have a third water body that I'm adding to this list that I'm keeping you up to date on. Welcome to the Gowanus Canal, Brooklyn's coolest Superfund site. If it's in Brooklyn, it has to be cool, right? So by definition. And I'm saying that having grown up in the Bronx. What can I say? Brooklyn is Brooklyn. Main elements of the remedy. The ROD, by the way, was issued in September of 2013. As you can see, dredging of sediment, capping of non-aqueous phase liquid, contaminated native sediments, off-site disposal, a lot of other things. All this stuff is in the materials. You can read some more. By the way, that 31 PRPs at the very end has now increased to 32 as well. I couldn't resist this slide as well. I actually was kind of disappointed. I looked this up. I thought this was, you could find this under the term punami. This is what happens in the Gowanus Canal after a storm. I didn't find it under punami. I was surprised, but you can look it up under this. You can see what's going on. I'd like to talk to you about a couple of very, very interesting bankruptcy settlements that we've had very recently. And then we're talking things that are wrapping up just around us, within the last couple of weeks. In January of 2012, Eastman Kodak Company, one of the truly iconic American companies, filed for Chapter 11 bankruptcy protection. We had a couple of Superfund sites that we were into Kodak for, so we filed a proof of claim, also some natural resource damages. So we had our proof of claim in there. It's fine. New York State DEC and the New York State Urban Development Corporation began negotiating a settlement with Kodak to deal with ongoing cleanup. There's a corrective action going on at Eastman Business Park, and also that will include the Genesee River. That's ongoing. And so there was a negotiation going on as to how to accomplish all of that and at the same time keep Kodak in Rochester for a while and all those sorts of things. Now, the agreement that was negotiated included a provision that EPA, it was all contingent on EPA providing a covenant not to sue, which kind of got us involved in it. And we found that agreement made a wonderful starting point for what turned out to be a fairly involved and long-term negotiation. I don't have time to really get into all the details, but what I'll do is just give you a little sense of how the payment structure is going to work, how this is all going to go forward in terms of the cleanup. Where we ended up, which I think is a very good outcome, because we have the cleanup paid for, and at the same time we're also doing what we can to encourage the redevelopment of the Rochester area. So the way it's going to work is we have the state of New York will actually assume the work. DEC is going to be doing the remaining cleanup. How are they going to pay for it? $49 million deposited into a trust. All right, and so that's going to be the first chunk of funding. It comes from various sources. I have detailed material on this in the materials that are online, and I also have the actual documents of the settlement, so you can look into that after this conference. But anyway, so now we have a couple of what-ifs. Right, so we've got $49 million in the trust. What if it costs more than $49 million? Could happen, right? We just talked about 3 water bodies that kind of pricey. I don't think I mentioned this little fact that the Passaic remedy, I believe the proposed remedy for the lower 3 miles, is I believe it's $1.7 billion. That's billion with a B. I believe that's the most expensive proposed remedy in the history of the program. So these things can get pricey, right? So what if? What if it exceeds $49 million? Well, in this case, New York State has agreed to step up and fund the next $50 million. Way to go, New York. Next, what if? What if it exceeds $99 million? Could, who knows? I mean, we're still learning about the Genesee River. In that case, Kodak and New York State will each fund 50% of the additional costs. All right, now I see my time is running down, so I'm going to run to the next interesting bankruptcy settlement. Tronox. Oh, and by the way, I should say that in terms of currency, this settlement was approved 2 weeks ago. All right, so the bankruptcy court, Judge Gropper in the Southern District, approved this settlement, and it's in place and ready to go. Tronox bankruptcy. This is another one that was approved, as it turns out, just yesterday. But in August 2008, DOJ filed a CERCLA cost recovery action against Tronox. All right. This was for, the Tronox was the former Kerr-McGee Chemical. It was one of the responsible parties at one of our Superfund sites, the federal creosote site, Manville, New Jersey. Okay, so there was an initial bankruptcy settlement, 2010, provided that Tronox would pay about $270 million for environmental liabilities, which was really not very much in terms of the Superfund sites that were involved. But we also agreed that we would get 88% of Tronox's interest in the then pending fraudulent conveyance litigation against Anadarko and Kerr-McGee. All right. So, and this alleged kind of the obvious, that Tronox, when it was spun off, was given all the environmental liabilities and was not given sufficient resources to satisfy those liabilities. In 2012, there was a trial. The trial lasted, I think it was 36 days. Is that right, Rob? 34 days. 34 days of trial in the Southern District. By the way, it's Rob Yalen, who headed the Department of Justice litigation team in this matter. That was in 2012. In December 2013, the defendants were found liable. Judge Gropper, yes, the very same Judge Gropper who presided over Kodak, he's had a busy year, deferred at that point on ruling on the exact amount of damages that were going to be associated with his finding. He wanted to have a hearing on damages and so forth. And we were kind of looking at this whole thing, seeing how it was going to go forward. There was going to be an appeal and so on and so forth. So we ended up settling. And the settlement, which occurred in April of 2014, is for $5.15 billion. Again, that's billions with a B. And I understand, Rob Shaker, nod your head, I believe that's the largest environmental settlement in history. He's nodding. Always a dangerous comment to make, but the largest one in history. And as I say, that was, in fact, approved just yesterday. Okay, I see my time is up. I will go to that last slide. The point that I wanted to make about this, we didn't really talk very much about the Caribbean. Judith Enck, our regional administrator, will be doing that later on. Stay here for the keynote address. I promise you're going to enjoy it. She'll be talking about the Caribbean, but we've been doing a lot of work in the Caribbean, including in the landfills, and the main theme about all of this is that when we reach settlements in Caribbean landfills, we are seeking recycling, and we're getting it. We're trying to encourage recycling in Puerto Rico to try to reduce the waste stream. And with that, I think I'll close. Thank you very much, everyone.
Thank you, Eric. Up next, we have Paul Simon, the Deputy Regional Counsel for EPA Region 2. Paul has been with EPA since 1985. Paul?
Good morning. So we're going to shift a little bit from putting people in jail to something a little more warm and fuzzy, EPA's focus on communities. Making a visible difference in communities is one of Administrator McCarthy's themes that she set for EPA, as Eric mentioned. It's really one of the key strategies in EPA's, in our latest strategic plan, which just came out. It calls for incorporating community-based strategies as a fundamental organizing principle in EPA's core programs and policies. This involves many different actions across the agency, such as doing improved, meaningful outreach to communities and incorporating more community-focused approaches in our regulatory and enforcement actions. The goal of making a visible difference in communities has two pieces to it, the visible part and the impact part. We want to have a positive impact at the community level. We also want the community to understand the impact that we're having. The better the community understands the programs we have, the services we provide, the easier it is for us to find out about problems and to address them. So obviously almost everything EPA does can be said to have a positive impact on communities or to be attempting to have a positive impact on communities. And it obviously covers a lot more than I can discuss in 15 minutes. So what I'd like to do is focus on four specific aspects of this theme that I think may be of particular interest to you as environmental lawyers. First, the enhanced efforts EPA is making to provide information to communities about its enforcement actions and about the compliance status of specific facilities. Second, our efforts on environmental justice. Third, our citizen science initiative. And lastly, the way in which supplemental environmental projects, or SEPs, in our settlements are a way of helping communities. So to start with, one of the ways that we're increasing the visibility of our enforcement work in communities is simply by making a more concerted effort to let the public know about our case-specific actions, enforcement actions. If you follow Region 2, you may have seen a pretty significant uptick recently in the number of enforcement-related press releases that we're issuing. In the last few months, for example, we've issued about 15 press releases covering enforcement actions we've taken in New York, New Jersey, Puerto Rico, and the Virgin Islands under the Clean Water Act, Clean Air Act, RCRA, FIFRA, Safe Drinking Water Act, CERCLA, et cetera. For instance, just a few days ago, we issued a press release announcing the results of 30 inspections that we had done to see whether facilities were complying with the chemical inventory requirements of EPA. We listed the 17 facilities where we had found violations. And as we've increased the number of press releases and other press events that we're doing about enforcement activities, we have seen an increase in the local news coverage of our enforcement work, and I think that's a good thing. So now, basically, any time we do a significant enforcement action, whether it be a settlement or a more unilateral action, there's a very good chance that we're going to want to publicize it through a contemporaneous press release, so that not just the regulated industry, but also the local community can learn about the action we took and the benefits of that action. Another good tool that you may be aware of already that informs people about enforcement actions taken against facilities in their community and the compliance status of facilities is EPA's ECHO, Enforcement Compliance History Online tool. Some of you may use it already when you're doing due diligence work, for example. While it's been around for a while, EPA is improving this tool on an ongoing basis. Here's what the ECHO homepage looks like. Community members can use it to get an overview of facilities in their area. For example, they can find every Clean Air Act regulated facility in a given town or a given zip code. They can find every facility with an NPDES permit or with a RCRA ID number, et cetera, et cetera. They can also drill down to get information on a specific facility and its current compliance status and compliance history across all the relevant environmental statutes. You can just keep clicking to get more and more detailed information. You can also download data sets. As I say, EPA is enhancing this tool on an ongoing basis. We're adding new search features, new data sets. So it's really a great resource to be aware of, and I think it empowers communities. The second area I'd like to discuss quickly is environmental justice. Now, needless to say, there are many conferences just on environmental justice, and I'm going to try to touch on it in just a few minutes. What I'll do is try to just focus on a few particular aspects of our EJ program. As you may know, EPA issued Plan EJ 2014 a few years ago. The EPA regions and the national program offices have been implementing it since then. It's our overall roadmap on integrating environmental justice into our programs and activities in order to protect public health in communities that are overburdened by pollution. I've included the executive summary of this plan in your materials. Some of the specific goals of Plan EJ 2014 are to incorporate EJ into EPA's rulemaking processes, to consider EJ in environmental permitting actions, and to advance environmental justice through compliance and enforcement. The EJ permitting initiative, which is one of those things, the goal of that is to enable overburdened communities to have full and meaningful access to the EPA permitting process, and for EPA to address EJ concerns in its permits to the greatest extent practicable under environmental law. Region 2 just issued a regional implementation plan last year to promote the meaningful engagement of overburdened communities in the region's permitting activities. I've included that plan in your materials. The other regions and headquarters issued similar plans. Our regional implementation plan on permitting lists certain categories of permits. For example, Clean Air Act PSD permits as being priority permits for EJ purposes. We'll then use a tool like EJ Screen, I'll talk about that in a second, to help determine whether the community that would be affected by one of these permits already is in an overburdened community. If it is, we'll develop an enhanced outreach plan that ensures that the community can participate fully in the permitting action and that its concerns are taken into account. That might involve us doing things like extending the public comment period, holding extra public hearings, maybe translating documents, requiring the permit applicant to write and issue some plain language summaries, and so forth. By doing enhanced outreach to communities during the permitting process, we can get information that's relevant to the decision to issue the permit or to the conditions to require in a permit. For example, based on input from a community, we may decide that it's necessary to require some additional monitoring or additional reporting by the permittee over the life of the permit. Now remember that the federal executive order on environmental justice from President Clinton in 1994, that doesn't dictate any particular substantive outcome in a permit decision. Our decision on whether to issue a permit and the conditions to include in a permit are always going to be based on federal statute and regulation. But that said, environmental laws do give us a number of ways to address EJ concerns, and I'll talk a little bit more about that in a second. EPA has also built EJ into its enforcement program, of course. This applies to the whole enforcement life cycle, starting with our factoring EJ considerations into the selection of our priorities, national and regional priorities, to considering EJ in the targeting and development of individual cases, to considering EJ concerns as we fashion remedies in a particular case, and then communicating with the public once a case is resolved. Over the last year, EPA has started using this tool I mentioned, EJ Screen, which is a new EJ screening and mapping tool that helps prioritize our enforcement efforts in geographic areas that may be experiencing disproportionate environmental impacts. A public version of EJ Screen should be coming out this fall. The tool combines environmental and demographic indicators to create an EJ index for a given area. The EJ index isn't going to be sort of the be-all and end-all, the only thing we'll consider, but it's will be one factor that will inform our enforcement work. One example of EPA Region 2 factoring EJ concerns into its enforcement and compliance work and thereby make a difference in communities, and one, by the way, that ties in with Joe Siegel's presentation about climate change, is our recent initiative in New York City and places like Newark and Paterson, New Jersey, to inspect oil storage facilities and chemical and hazardous waste facilities that are in low-lying areas, which could pose a threat in the event of a severe storm. Because of where these facilities are located, obviously, they have the potential to put the health of nearby communities at risk and contaminate nearby water bodies during and after severe storm events if they don't manage the materials properly or they don't take appropriate precautions. New York City environmental justice groups have specifically raised concerns about this. So the Region 2 initiative has included doing multimedia inspections of these facilities to identify and correct compliance issues, and in some cases providing environmental assistance to the facilities, in which we recommend that they take some additional steps to minimize the impacts that they would have during a severe storm. In the last year or two, we've conducted something like 80 inspections of these sorts of facilities in the New York, New Jersey metropolitan area, checking on their compliance with SPCC, facility response plan requirements, risk management plan requirements, Clean Water Act rules on stormwater, EPCRA requirements, hazardous waste management, underground storage tank requirements under RCRA, and so forth. I mentioned a second ago that federal laws do give EPA a number of authorities to factor EJ concerns into our decisions and activities. To help EPA staff understand the legal authorities that they have to address EJ concerns in their day-to-day work, our Office of General Counsel issued a compendium in 2011 called EJ Legal Tools. It summarizes the many discretionary legal authorities EPA has under federal law to address EJ concerns as we implement our programs. EJ Legal Tools is over 100 pages long, so I just included the table of contents in your materials, but it'll give you a sense of the very broad range of authorities that it covers, and you can access the whole report on EPA's website. some of the legal tools that are discussed in it are already being used by EPA. Okay, the third area I'd like to discuss quickly that sort of illustrates the efforts we're making in communities is our citizen science program. It's something that EPA Region 2 is really prioritizing. As the name implies, citizen science refers to scientific investigations, for example, environmental sampling, conducted by citizen volunteers. And we're encouraging citizen science in a number of ways. We've held citizen science workshops, forums, we've provided training, we've issued grants. We've also provided funding to New York and New Jersey state agencies for citizen science. We recently upgraded our website on citizen science, and it's really very useful for communities. It gives people detailed information on how to do different types of sampling, how to do quality assurance, lets people know where they can apply for grants, and so forth. Citizen science really raises communities' awareness of their environment, and it can lead to stronger public health and environmental protection. And one terrific example of this relates to what Lori was talking about, the Tonawanda Coke matter. Community members in Tonawanda were very concerned about air quality in their area. They have 53 industrial facilities there, and they took the initiative to do air sampling themselves. In their community, which found high levels of benzene and other contaminants. They gave the data to EPA and DEC. DEC then did its own air study and provided the data to the citizens groups, and that helped the citizens groups sort of advocate for strong enforcement action. And that eventually led to not just the criminal work that Lori mentioned, but some civil enforcement, a number of civil enforcement actions against Tonawanda Coke Corporation. And the company ultimately agreed to upgrade its pollution controls and its operations. So it's a wonderful success story of citizen science, and you can see a video about it on EPA's website. The final illustration I'd like to give you of our focus on communities is SEPs, Supplemental Environmental Projects. As you probably know, these are environmentally beneficial projects that a regulated party commits to do in a settlement with EPA in return for a significant reduction of the penalty that it has to pay for its noncompliance. SEPs have to meet certain criteria. They can't be something the company was going to do anyway. They can't be something the company is required to do. And there has to be a nexus between the underlying violation and the benefits that the particular SEP will provide. There are many different types of SEPs. There are pollution prevention projects, audits, environmental restoration projects. The list goes on. SEPs can really be a win-win for everyone, including the local community. The violator reduces the penalty that it has to pay, while at the same time protecting public health and the environment in ways that go beyond compliance. So often when we negotiate settlements in civil penalty cases, we'll encourage the regulated party to consider agreeing to conduct a SEP. We especially look for opportunities for SEPs that will promote environmental or health benefits in a community. In the last few years, for example, we've entered into Clean Water Act settlements that included SEPs that will reduce stormwater impacts. Recently did a Clean Air Act settlement with a SEP involving supporting a municipal recycling program. Clean Air Act and RCRA settlements involving SEPs that included installing release detection equipment that went beyond legal requirements, many other examples of SEPs. So these are things that we really look for in our negotiations in cases where civil penalties are at issue, and they really provide benefits to the local community. You can learn more about our SEP policies on EPA's website, of course. So very quickly, this was sort of a whirlwind, just a few examples of the things we're doing to make a difference in communities. It's a theme that really pervades EPA's work. There's a little more information in my materials that you have, and as my colleague said, you can learn more on EPA's website. Thank you.
Wonderful. Thank you, Paul. I think we now have about 15 minutes for any questions. Yeah.
No, it just says he's responsible for paying the $20,000. if someone else pays it on his behalf, there's no way of policing that. We wouldn't know.
Okay, so we could conceivably have paid it and then gotten it back from the company or insurance policy?
Insurance policy, I don't think so. Whether the company gives him any reimbursement, we would have no way of knowing that.
It's your judgment, however, this would not have imposed that on the person.
The judge could have. I mean, the judge has broad discretion, but he did sentence Mr. Krumholz to a $20,000 fine. And that's the extent of it.
Yes? You can turn on your microphone.
Two questions for two different panelists. One, I think, Eric, you mentioned open flare petroleum facilities burning, and I wondered what kind of a regulation that is covers that, and does it also cover deposition off-site at the facility? I'm working on an open burn issue in Los Alamos where they're burning high-level explosives, and one of the concerns was that. But the other question I have is, what kind of evidence did you adduce from the record that was convinced you that there should be criminal charges brought? I mean, you have a very heavy burden of beyond a reasonable doubt that somebody committed a particular act, and that they had the specific intent to do that. And what you mentioned was that they didn't report this flange or valve. Did you have eavesdropping warrants? Did you have pen registers? Did you have any other kind of under surveillance techniques, undercover agents wired, things like that?
Lori, I'll go first. Rich, with regard to your question on the flaring, there are actually very stringent requirements for flaring. One of the things that we find is most often a problem in terms of reaching the combustion efficiency that's required is something called over-steaming. It's a way of balancing the way the whole process works in such a way that, unfortunately, the combustion efficiency is not reached and you have excess emissions coming out through the flare instead of burning it as you should. So, now,
Can you actually put a permit condition in that would require a particular operation to meet that combustion level?
the requirements are already there. They're pursuant to the air toxics standard.
And how do you enforce that? I mean, how do you get there into the facility to do that?
We just do inspections. I mean, that's how we're doing it. And we're finding a fair amount of noncompliance. And those
Yeah.
two settlements.
I know, I live in Jersey, I know.
Yeah, well, there you go. And there's more about all that on our website. We have a whole section of our website that's devoted to the initiatives, and air toxics is prominent in that. I'm not aware, that particular requirement certainly doesn't deal with off-site deposition. There may be others, but
Could that be a problem, though, or could you see
I want to give
that?
that one some thought.
Yeah,
Okay, thanks, Rich.
okay, thank you.
Lori? Lori, did you want to?
Yeah, okay. I can't go into all the specifics, but what I can tell you, there isn't just one piece of evidence that convinced us that there was criminal activity. I mean, it was a, many months, year-long investigation. So it included talking to employees at the facility, looking at the record that was there in the state files as well as EPA files. There was a grand jury that was impaneled. And testimony that was presented at trial. When you look at their permits and what was required by their permits, for example, having the baffle systems installed and you did not have baffles, there was testimony by a state inspector that
But did you
they were
have
told-
actual statements within
Yes.
the company that they knew that those things were going on and that they knew they were in violation?
Yes, we had testimony from a state inspector said, I told them you had to have baffles. Mark told me that he put them in, but, it wasn't confirmed.
No, but I'm talking about in-house correspondence between key officials in the company indicating a recognition that they were in violation. That kind of proof.
There were some of those things that were discussed at sentencing that they weren't presented at trial because we couldn't get them in under the rules of evidence, but we did talk about them at trial. For example, that concrete pad, there was a corporate memo that discussed that they installed the concrete pad for that exemption.
Is there an
They didn't
appeal on
use-
this case?
They have filed a notice of appeal.
Okay.
Yes?
This is directed to Eric Schaff. What baseline measurement review exists in terms of gathering information on fugitive methane emissions from gas pipelines, as well as consistent rolling radon monitoring from the pipelines, specifically to New York City, the Spectra pipeline coming into Lower Manhattan, delivering Marcellus shale gas, which is extremely high in radon 222? The leading cause of lung cancer, as the EPA is well aware of in the United States. What existing measurements are being taken, about the methane fugitive methane emissions, as well as the radon 222, which is coming into New York City because the Spectra pipeline has been hooked up since November 2013, and no EIS has been done on that particular pipeline for 1,500 feet in Lower Manhattan.
The short answer for me is I don't know. But there's some folks in the room. I would just want to see if Liliana or Ed McTiernan, who's here from the state of New York, whether you know anything about the issues that have just been raised, what kind of monitoring is being done on those pipelines. Liliana, do we know anything about it? Yeah. So we're going to take that back and discuss it internally. Ed, anything on the state level? Ed McTiernan? Oh,
I think he's
he
left,
stepped out.
or he went out.
Okay. So we'll take that one back.
Yeah?
For Mr. Schaff as well. With respect to the Hudson River cleanup, my understanding is that there is still a lot of residual contamination in the lower part of the upper river because initial sampling that the rod was based on did not discover a lot of contamination that was later found to be there. And I was disturbed to hear that the dewatering plant was being decommissioned in 2016. Is there any hope of that residual contamination being addressed in some context?
We would have to go over what you're actually referring to. We can sit down with the rod. The decommissioning will occur when the sediment has all been removed and dealt with pursuant to the rod. Anything that's not covered by the rod, the decommission, the dewatering plant, that's what it was built for. It was built as part of the remedy. Now, there was always, there was never going to be a bank-to-bank dredging of the Hudson. It's just too much. Think about the number of miles and all of that. So there's always going to be something left. But it's left at low enough levels, and it didn't present a threat that we could respond to. But anyway, Walter will be talking a little bit more about that in the next panel, so perhaps we can hold that over for the next panel and see what Walter's thoughts are on that as well.
Thank you.
Yes?
New York State has, I think, a really good bad actor policy in terms of people get penalized in future contracts. Has EPA been working with something similar?
Could you describe the circumstances? Bad actor policy and other...
If someone gets caught with violations,
yeah,
they can't get new contracts, so there's increased restrictions on their...
There certainly are restrictions on the federal level with regard to prior activities.
But is there a plan to have the city, state, and feds work together on such a policy? It just seems that the city, we keep on catching repeat violators, and they still keep getting contracts. They're allowed to get contracts. We're just
we're pretty strict in auditing that whole process of EPA grants. For example, we've been pretty active in the Caribbean recently, and in Puerto Rico, it was recently removed from the high risk grant status, and the USVI was put on it. So we're monitoring this very closely. In terms of specific examples in New York State, maybe you could give me a couple of the things that you're thinking about in particular, and I can look at those specifically.
Okay.
Yes?
This is a question for Laurie. Mark was the only person, Mark Krumholz, that you convicted individually in the Tonawanda case. Was there anybody else that you looked at? And was he that you investigated, and was he the highest environmental officer in the company?
I can't discuss who we looked at in terms of our investigation, but in terms of Mark Krumholz's position, he was the environmental compliance manager, and the only person that he reported to directly above him was the president of the company.
Yes?
It's hard to discuss a criminal case in a place like this.
The court's definition was the clearest and simplest definition, and it was looking at guidance documents, because that's all there is on what that term active management and what it means. And so they picked the most succinct definition for that term. The defense did not invoke like Chevron or anything like that, or the rule of lenity. It did not.
Wonderful. Well, thank you, Eric, Paul, and Lori. I think this concludes this panel.